Good afternoon. Thank you for joining us today for this important discussion. My name is Jesse Smith, and I am the president of the American Constitution Society at IU McKinney School of Law for the coming year. Before we get started, I'd like to take the opportunity to answer an underlying question for today's event. What is the American Constitution Society, or ACS? ACS is a national network of lawyers, law students, scholars, judges, and policymakers who believe that the law should be a force to improve the lives of all people. ACS works for positive change by shaping debate on vitally important legal and constitutional issues through the development and promotion of high-impact ideas. If you support these efforts and are not a formal part of our network, I would encourage you to become a member of ACS today. With that said, I would like to take a moment to thank everyone who made this event happen. The members of the panel, our national and professional ACS mentors, the McKinney faculty and administration, Dean Klein and Dean Bravo, our technology partners, and especially the members of the ACS McKinney Executive Board who have worked tirelessly in reestablishing our organization and coordinating this event. Lisa Rowan, Cassidy Klaus, Katie Spear, Payson Corbett, George Sorrells, Caleb Hobgood, and Whitney Grout. And finally, thank you to our moderator, Professor Jennifer Drobak, who, after clerking for the Honorable Barefoot Sanders of the U.S. District Court for the Northern District of Texas and practicing law in California with a focus on employment law and litigation, Professor Jennifer Drobak joined the faculty here at IU McKinney in 2001 and is now the Samuel R. Rosen Professor of Law. Professor Drobak teaches courses in family law, juvenile law, sexual harassment law, and criminal law. Professor Drobak has recently contributed a chapter entitled Sexual Harassment Policy in the U.S. in Comparative Perspective in the upcoming publication Companion to Sexuality Studies. I'm honored to turn the virtual dais over to her now. Thank you, Professor Drobak.
And thank you, Jesse. I'd like to start this panel today by giving you all a quick introduction of our four panelists and then getting right into the questions to help us explore qualified immunity for reform. Our first panelist is Ms. Stevie Pactor, who is a staff attorney with the ACLU of Indiana. Ms. Pactor began her legal career as a law clerk to Judge Michael Kanne of the Seventh Circuit. After joining Sidley Austin LLP complex commercial litigation group in San Francisco, Ms. Pactor came home again to Indiana to serve as a law clerk to Judge Tanya Walton Pratt and Chief Judge Jane Magnus-Stinson of the Southern District of Indiana. Our next panelist is Senator Greg Taylor, who became a member of the Indiana Senate Democratic Caucus after being elected to represent State District 33 in November 2008 as a business and government attorney. Taylor joined the Senate with a breadth of knowledge and experience regarding economic development and job creation. Throughout his tenure as Indiana State Senator, Senator Taylor has been unwavering in his push for legislation that improves and protects the lives of all Hoosiers. Our next panelist is John Kautzman, who is a partner at Ruckelhaus, Kautzman and Blackwell, who has served as the Indianapolis Bar President and is listed in Best Lawyers in America. Mr. Kautzman represents individuals and organizations on a broad range of legal matters and focuses primarily in general litigation, criminal defense, personal injury, and law enforcement discipline and liability defense. And our final panelist is Michael Sutherland, who is a sole practitioner in Crawfordsville, Indiana, with a focus on civil rights and constitutional law. In practicing law for 45 years, Sutherland has successfully litigated numerous wrongful shooting and in-custody death cases, including a case heard before the U.S. Supreme Court on the issue of prosecutorial immunity. Michael continues to advise young lawyers on police misconduct cases. Now that you know a little bit about our panelists, we're going to jump right into the questions. If you think of any questions during this panel, please type them in the chat function, which the ACS Executive Board will be monitoring. We will be leaving about 15 minutes at the end of our prepared questions to ask questions from the audience. Our first question, question number 1, is directed to Ms. Pactor. In 1981, Congress created a private cause of action against state officials who violate a citizen's constitutional rights and protections. How did qualified immunity, a judicially created exception to this statute, come about? How has it developed since its creation in 1967?
Thanks, Professor Drobak, and thanks to ACS and McKinney for organizing this panel. Seems particularly timely given the conversations we're currently having about qualified immunity and all kinds of other issues. So I think it's important for us to situate ourselves first in the 1983 context. So that's what we're talking about here. When it comes to instances when qualified immunity is likely to appear or apply, we're talking about individuals raising civil rights lawsuits claiming their rights have been violated, their constitutional rights have been violated by a state actor. And the really shocking in some ways thing about qualified immunity is that it provides an exception to liability that is unlike exceptions that exist in most other contexts. So what qualified immunity is saying is, okay, all right, we can all agree that there's a constitutional problem here, but even if there is, we're gonna overlook that, and we're gonna say that this particular person can't be held liable in those circumstances. It's truly an astounding thing, and it's worth all of us thinking about, what does that mean from a policy perspective? What are the reasons for and against that? And what should it really look like moving forward? So in 1967, the Supreme Court really created the initial version of this doctrine. And at that time, what it said was, it's aimed at public officials, and it says, public officials who are acting in good faith in their official capacities and who believe that their conduct was in line with the law, but who later turn out to be wrong, are not going to be able to be held liable for that conduct. And you can see a certain rationale behind that, particularly as it's applied to police officers, and that rationale went something like this. We want to give police officers or public officials the ability to make, quote, reasonable mistakes about their conduct and how that conduct did or did not conform with the law. So again, it's worth querying whether or not we want that kind of exception in our society. Do we want for anyone to have that kind of exception? And if so, who should those individuals be in and what circumstances? And I think it's also worth acknowledging that your answer to that question is pretty likely to depend on your individual lived circumstances. What is your experience with public officials, with police officers? And that's likely to influence sort of the propriety that you think may exist in providing this fairly broad doctrine. Now, that's all well and good. We had this officers acting in good faith and a reasonable belief as to their conduct. But in 1982, the parameters of that doctrine changed pretty dramatically in a case called Harlow. So now, instead of it being a good faith basis, actually the basis of an officer's belief doesn't matter. And instead we have a two-part test that says, okay, number one, did the public official violate someone's right? And if so, was that right clearly established? Now, there are a few interesting things about that test as it's established. Number one, look at intent. There's no indication as to intent in that formulation. So it could very well be the case now that an officer knows that their conduct doesn't conform with the confines of the law. That's no longer a problem under this new test. The other thing is that even though it's a two-part test, the Supreme Court has been very clear that a court need not reach both prongs. And we can talk about this more later in terms of how this plays out in practice. But what this means is that if the court finds that in the second part of the prong, the right was not clearly established at the time the behavior occurred, the court need not decide whether that right was actually violated. That turns out to be a huge deal in qualified immunity doctrine, because what we now have is an extreme paucity of case law establishing what an individual's rights are. Now, the other thing to remember about this test is that, number one, the right is not a right very, very ambiguously defined, like the right against unlawful search and seizure. The Supreme Court has also made clear that the right at issue involves the individualized facts and circumstances that occurred on the ground when the alleged violation occurred. So right now we have a situation in which most cases are decided not on the basis of whether or not a constitutional right was actually violated, but instead whether there is a clearly established constitutional right that may have been violated if the behavior was as alleged. So I'll stop there. There's much more that could be said, but fellow panelists.
Okay, great. Thank you so much. All right, let's go to our next question, which I'll direct to Senator Taylor. How has the qualified immunity doctrine impacted the trust communities of color have in law enforcement? And could you explain how comprehensive hate crime bills could address the trust or lack thereof at the state level?
Yes, thank you. And again, thank you to ACS for having me to be a part of this very prestigious panel. Let me start with your second question first, because I think to establish some type of precedent in Indiana, we need to talk about what we have from a hate crimes legislation standpoint here in Indiana right now. Some of your viewers might not know, but I was one of the huge proponents of what I call a comprehensive hate crimes bill in the state of Indiana. What happened during the Indiana General Assembly and our establishment of what we now have coined our hate crimes bill, we specifically wanted to delineate certain characteristics for people of color, people in the LGBTQ community, women, the elderly, other things, children, and we wanted to have those specific words delineated in our law. Unfortunately, what we call bias crimes in Indiana that we have applies similarly to someone who, for example, has gray hair, the same as someone who has brown skin. So we could have been more deliberate. However, that was not something that we did in the General Assembly, and those of us who supported a comprehensive hate crimes law in Indiana did not vote for what we have currently in law. So glad to hopefully your viewers understand that position. But going to your first question about qualified immunity and trust in the communities of color, in order to understand qualified immunity, it is a difficult conversation to have, because while I also represent the government, I am one who is covered by qualified immunity. I'm covered in the fact that what I do and how I act in the general public and do certain things, that I'm protected because someone might consider suing me personally. And because I'm a government employee, I would be covered under this implied immunity is what I call it, not qualified, but implied, because there are numbers of individuals who are covered by this. Now, what happens as a communities of color is when you are, for example, pulled over for a traffic violation, and the police officer pulls you over and says, hey, you violated this traffic, you have an infraction, I can give you an infraction, but is there anything else that I should be concerned about when I pull you over? That has started another discussion amongst the minority community, and actually goes to the crux of the question why we don't trust law enforcement. If you are asked then, can I search your car? Most people would say no. If that officer then has probable cause to search your vehicle, then what they believe to be probable cause, that will be covered as not violated under the qualified immunity and not violating your rights. And that is a problem. And that's the crux of the problem in the minority community, is that where a simple traffic violation in a lot of cases could lead to some other constitutional violation of your rights. Right to reasonable search and seizure, as I brought up in this example. In addition, if Section 1983 under the federal statute doesn't apply, remember, we also have qualified immunity in state law. Now, there are many procedural processes that you have to go through in order to actually bring a case. Different notices have to be prepared. You're limited on the amount of punitive damages that you can actually achieve. So a lot of individuals do pursue the federal statute. But we do have an Indiana qualified immunity that's similar to that at the federal level, and we have case law in Indiana to address that. So representing communities of color, right now, this discussion is part of the ongoing discussion of what we see in police brutality across the state of Indiana.
Okay, thank you, Senator Taylor. Let's go now for question 3 to Mr. Kautzman. How does qualified immunity affect an officer or a particular case? What is your view of the legal and historical rationale supporting qualified immunity?
Well, thank you very much, Professor. I think I want to start talking a little bit about making sure we understand what qualified immunity is and what it is not. We've talked about what it is, and that essentially qualified immunity can be granted to a police officer if there isn't a showing of a clearly established right. But there's also certain exceptions to that. One is that if it's an obvious or sufficiently clear unlawfulness, the courts don't have to go through that. They can deny the qualified immunity and proceed with the case to trial. The other thing to point out is this is only a partial protection to civil liability and civil personal liability. It does not prevent the person from suing and prevailing against the government entity. It obviously is not absolute immunity. It is only qualified. It offers no protection to police officers for criminal charges to prevent them from being terminated from their jobs. It doesn't prohibit injunctive relief. So it is a narrow set of protections for the individual police officer. Now, if you look at the historical underpinning and rationale, the U.S. Supreme Court said in one of its opinions that the doctrine is intended, quote, to protect officials who make reasonable but mistaken judgments about open legal questions. And I think that's going to be something that I'm going to talk about a little bit later, but that open legal question comes to the issue of what fair notice is the police officer on, what has he been put on in terms of a fair notice requirement to be able to conform their conduct. I think we also need to point out that qualified immunity is not, I don't think, an epidemic gone amok. There's a UCLA law school study that's out there that showed that out of 1,200 cases that they reviewed, only 3.9% of those cases that qualified immunity could have been raised did it result in dismissal on qualified immunity grounds. So I think it's hardly an epidemic, and I think we need to be a little bit more measured about our discussion of potentially throwing the entire concept overboard. So I think it's a reasonable defense. I think the effect on given officers is multifaceted, frankly, but it leads into several well-stated historical bases. In terms of the historical basis, if you will, there are several historical bases and benefits that have been identified in the case law. To avoid the time and expense of litigation, especially attacking it in the early stages of the case, which can save time and expense for everybody. That personal financial liability against individual police officers would deter police officers from becoming police officers and anyone else. As Greg Taylor points out, it doesn't just apply to police officers. So several public government officials would be deterred from coming in to that line of work. It has a grounds in trying to avoid insubstantial or frivolous lawsuits without proceeding to trial. It could have a chilling effect on police officers doing their job where they have some general idea of how they're supposed to handle a specific scenario, but in these ever quickly evolving, rapid changing circumstances, they don't want to be in a situation where they got to stop and think through, if I do this, this, or this, am I going to get sued? They have to rely on their training. And that ultimately takes me to, I think, what the biggest point that I read in the qualified immunity cases is that the core of the Supreme Court jurisprudence is this concept of notice, that it would be unfair to hold government officials to constitutional rules if they weren't aware of what they were supposed to do at the time. In other words, were they on notice of the unlawfulness or the correctness of their conduct? And I don't think we ought to have that big of an issue with giving someone fair notice before we hold them liable. That concept is all across the legal landscape. In a contract, parties are told what they are able to do and not do without breaching the contract. In tort liability for premises liability on a slip and fall case, the landowner knows what duties they have to abide by to avoid liability. All we're talking about in qualified immunity on a clearly established right is, was the officer on notice that their conduct was going to be held violative of the Constitution? And I don't think that's a radical concept for officers to have that kind of fair notice. You know, officers are trained as to what to do. They need specificity in the scenarios that they go through on the fine details of when you can touch someone, how you can touch someone, what's an appropriate takedown, what's not, all those kinds of things. And so I think if you go in a reasonable and measured way through the Supreme Court case law, you'll see that there is plenty of fair-minded rationale for the concept being a viable and fair concept.
Okay, wonderful. Thank you, Mr. Kautzman. And now I want to go to our question number 4 to Mr. Sutherland. How has qualified immunity become so integrated into our federal justice system under 42 USC section 1983? And does the term every person acting under color of law, does that apply to police?
Okay, now I'm there. Technologically. So thank you very much for having me on this panel and for the Constitutional Society to organize this. Let me touch on a couple things that came up, if I may, because there's, in some ways, the panelists have their little silo. Senator Taylor is protected by absolute immunity as a legislature. And the 1971 Act was a Ku Klux Klan Act, and it was intended to address systemic racism and excessive police actions in the country. And the history, the legislative history, does not indicate any qualified immunity exception whatsoever. And let's put this in the context of what's going on. You have, over the course of not very long, maybe 2 or 3 years, the horrific death by choking of George Floyd in Minneapolis, the shooting of Rayshard Brooks in Atlanta, the shooting of many times of Breonna Taylor in Louisville, the choking of Eric Garner in New York City, and the shooting in Ferguson of Michael Brown, an 18-year-old who was shot 6 times. The officer resigned, and there was never any prosecution. Benjamin Crump, their attorney, secured $1 million settlement, I am told. So qualified immunity is a fiction created by the court. It's the most insidious Supreme Court created doctrine that shields police from liability and from going to trial, as Mr. Councilman said. The Supreme Court has created this, and you would think that you would have enough landmarks or enough red lines to put police on notice. The fiction, though, is this, and it's a very dishonest proposition. The reasonable police officer is supposed to intuitively know what the limits of his police power are because of case law. Case law. What police officer reads case law up to date? The second part is that a clearly excessive force case, an unjustified shooting, can be protected by qualified immunity because you cannot find an identical or closely analogous situation in the case law that the police officer will never read, but is supposed to have read. The other insidious part of this is that you would think that when a situation like that comes up where you have an extraordinary situation of excessive force, but because you can't find a precedent, you'd think that the court, the trial court or the circuit court would say, okay, from now on, a situation like this or similar to this shall be seen as unconstitutional, as an event which violates the citizens' rights of due process to be free from unjust punishment. But they don't do that. So you don't have the Supreme Court, the circuit courts, or the trial courts creating this case law which would inform the reasonable police officer. And that's pretty insidious. It is also a block to any litigation. So if you file your lawsuit and you know you're going to be hit by qualified immunity, the defendants may also ask for a stay of discovery. So you can't even get discovery. And again, one of the most terrible things that I've seen in the course of the 45 years is that the federal courts do not allow hearings for this. The state court will have a hearing almost on everything. So your arguments about qualified immunity, either in responding to a motion to dismiss or in summary judgment, it's just throwing paper back and forth at each other. You never have a hearing. The court never gets to see the parties. In fact, you seldom see the parties until you go to trial. So let me explain how this works. Let's just say the defendants raise qualified immunity. It's their right to do that. They lose. They have an absolute right to appeal. Now they go up to the Seventh Circuit in our state, and that's usually at least a year to 2 year turnaround. So that's a delay. And what does delay benefit? It delay benefits the defendants every time. Now, Mr. Councilman talked about, the cops need to know where they stand and so forth. You don't have a similar requirement under negligence law. There's a presumption that the cop would know what the law is generally. That is, not to use excessive force, not to make a false arrest. But we now have a concept called qualified immunity, probable cause for probable cause. Can the officer show probable cause to have probable cause? That's how ludicrous it's become out there. That's the dialogue that's going on among academics and practitioners. So if you're going to have a big picture, you have to realize that the police officers are indemnified. Mr. Councilman didn't mention that. There's a contract with the city, and there is a state statute. And so the police officer is indemnified for everything but punitive damages and for conduct that is criminal. So if the act that he is accused of violates the Constitution, but he is charged criminally, he can still be personally liable, but he won't be indemnified. So what we're looking at here is a national reaction to a structural problem of systematic violence of police officers against the community. Each year, there are 990 to 1,000 police action shootings that result in a death nationally. That's an epidemic. And I'll just get back to you later with some more information. Thank you.
Okay, wonderful. So let's go on to the next question, which would be, and this would be directed at Ms. Pactor first. And actually, let me go ahead and read that. So, and each of the panelists can feel free to chime in. What does a qualified immunity case look like in practice? Is there a predictable progression and process?
Sure. So I feel like John and I should be tag teaming this question in a way, because we're really flip sides of the same coin. I practice for the ACLU of Indiana. I'm a civil rights attorney. I spend a lot of my time suing government actors. Almost every case is a qualified immunity case on some level. So when I'm deciding whether to take on the case, part of and how successful we're likely to be, I'm looking at what is going to be the qualified immunity defense that a defendant is likely to raise. And can I find in our state 7th Circuit case law that is directly on point? And you know, John's right to point out that there is this exception to the exception under Supreme Court case law that says, for a really obvious violation, you don't have to go through this finding an exactly analogous on point case. But it's hard for me to stress strongly enough how rarely that exception is actually used in practice. There are hilariously tragic examples of circuit courts throughout the country finding that certain legal propositions were not clearly established at the time. So things like police officers went in to execute a search warrant. This happened in the 9th Circuit. They stole $250,000 worth of property from the person that they searched. The 9th Circuit found that it was not clearly established case law, that was unlawful activity by the police. Why? Because there was no case law exactly on point. So it is true that exception exists, but it's not used as often as plaintiffs' attorneys think that it should be. And I think that it has led to a circumstance where, as Mike was suggesting, this exception to 1983 liability has in effect swallowed the right that was very explicitly given by Congress specifically for civil rights cases. So the short answer of the question is, for me, almost every case is a qualified immunity case. Usually defendants tend to raise it as early as they possibly can, for exactly the reason that it was developed to get those cases out of court as quickly as possible. But as Mike highlighted, of course, they come with a very unusual right to interlocutory appeal directly to the 7th Circuit. So this is a huge investment of time and energy of everyone in the case, not even getting to the point where you're litigating the merits.
Okay, thank you, Ms. Pactor. And let me go ahead and ask Senator Taylor and then Mr. Kausman and Sutherland if they have comments on the same question.
Although I'm a practicing attorney, I do not litigate. So I'm going to leave it up to the litigators to discuss this. But one thing that I do know is that when you look at the predictability, if any of us can determine the predictability of these cases, I can tell you that doesn't exist. I've read case law after case law, and don't forget, these are federal 1983 cases. We haven't even hit the ones related to state law in different states. So that, yes, it does apply, and I think it applies to a lot of people. And unfortunately, I think at this point, we see a lot of people manipulating that immunity.
Michael?
Sure. So I want to sort of, can you hear me now? I want to make sure I'm turned on. So the Washington Post conducted a study last year of police action shootings. And it's not just a problem within the Black community. In fact, most of the shootings that result in fatalities are white nationally. But blacks and Hispanics account for about 45% and whites about 55%. So it is not just race, but if you look at the national outrage, it seems to be based on race, perhaps because Black Lives Matter is much better organized than the rest of the society. But it is a systemic problem. So as the senator pointed out, this creative policing where they stop you for a taillight, you go back and say, hey, my taillight's still on, what was he talking about? Well, it was out when I stopped you, is pretextual. It's intended to create a situation, and if the driver doesn't cooperate, he's going to be charged with resisting. And then once he's in custody, now you can search the car. And if the car is then found, if you find a gun in there, or if you find marijuana or some other drug, now it just escalates. And so if the person wants to resist this, you know, it then can escalate into a physical confrontation. So back in the 70s, there was a study conducted by the New York Police Department, which, by the way, has 35,000 police officers. It's an army. It is an army. It's bigger than some of the armies in the world. And they decided that to avoid these problems of wrongful shootings and excessive force, you have to keep a distance. And if the person is perceived to, or thought to have a weapon, you index cover, meaning you get behind your car, you get behind a tree, and you give commands, and you wait. Patience is a big part of what you need to be as a police officer. You don't have to rush in there and be a cowboy, and you wait for backup. If you don't do those things and you get closer, now, as John Councilman said, it does become a split-second decision thing. But that's because the police officer created the situation by rushing in and getting too close to the person he was trying to apprehend. So you need to train the police officers to stay back and to give commands. And, you know, this whole thing about a knife, that a person can run at you with a knife, that's baloney. When I was in college, I had a person pull a knife on me. And what you do is you back up. You don't stay where you are. You don't pull your gun. And one of the things I've noticed is that the gun in a police officer's hands is now being used as an instrument of persuasion. Eat your green beans or I'm going to shoot you. Put your hands behind your back or I'll blow your brains out. If you try to run, I'll shoot you 50 times. That's not the use of a gun. And there are some departments which say that if you unholster your gun, you've already made the decision that you're willing to use it. And so you have to justify that unholstering. And if you can't justify it, you're going to be disciplined. Not whether you pulled the trigger, because you've already made up the mind you're willing to pull the trigger when you unholster it. And those kinds of things need to be addressed in this restructuring of police misconduct. So if you're going to really reform this, you have to do away with qualified immunity altogether. And I'll add one more thing. Qualified immunity does not apply to the private sector doing the same thing. So a private prison, like at Newcastle, and those guards don't enjoy qualified immunity. The Supreme Court reasoned if they're making that much money, they've already factored in, you know, their sort of liability costs, so they don't get qualified immunity. So a police officer who is hired by a security company doing, let's say, ambulance escorts or funeral escorts does not enjoy qualified immunity.
Thank you, sir. We're going to go on to our next question for Mr. Kautzman. What are the risks that you see to completely abolishing qualified immunity? And are there ways for the courts to solve many of the concerns being raised?
Yes, thank you very much. And let me jump into those questions. And then at the very end, I want to circle back to a couple points that my colleagues made. But in terms of just the general risks of abolishing qualified immunity, much of which is what I already talked about. Financial disincentives, deterring a qualified applicant pool. You will not see people coming into the policing profession if there's not some kind of reasonable financial liability protection for them. And it will also cause an exodus of experienced police officers. So literally you would have this domino effect where if you abolish qualified immunity, the city would be forced to re-examine its policies on indemnification. That would then force the police officers to try to see if they can go on the private market and get some kind of liability coverage, which they're not going to be able to do. then they'd end up quitting the profession. We'd probably end up with some kind of privatization in law enforcement. And then you'd ultimately end up with a situation where the wealthy people could pay for their own security forces, but we'd have tax increases to deal with a privatized security force for normal policing. So obviously some of this stuff could go ad nauseum to a ridiculous level, and I'm not saying it's going that far. I'm simply saying that there is a risk of taking a measured approach on what we're dealing with in qualified immunity. You know, lots of business professionals have some form of liability protection. Why don't we look at getting rid of LLCs or corporate liability shields? There's plenty of reasons that people put in place, and our legislature has put in place protections for people to be able to go into a business without having everything risking their personal assets being exposed. So I think those are some of the issues related to risk of completely abolishing. I looked at the Democrat bill that was in the House. That not only strips away qualified immunity, but it says things like it will no longer be a defense for good faith, for an officer to reasonably believe that their actions were lawful, to whether or not the right was clearly established or not, and whether or not the officer should have known that their conduct was lawful or not. At a certain point, you get to the point where there is no ability to have a defense, because the policemen are going to have to be guessing in the field on how to conform their conduct to what the court might later, 2-3 years from now, say was good or bad based on the cool confines of a courtroom at a later date. So I think it's not unfair. You know, many people say that the plaintiff's bar has difficulty in finding cases that they can use in the pleading and practice to point to what is a clearly established right. Well, it's no more difficult for them than it is for the police officer to have some kind of guidance on what is the right that they're allowed to act upon and what they shouldn't. I don't know, if, Professor, if you want me, since and timing, just quickly go into that last question on ways that we might be able to solve this thing. I think many police officers would agree that we could go into some reasonable amendments. We could go back to Saucier versus Katz, the original Supreme Court case that had the two-part inquiry that stopped, that would stop courts from jumping right to the clearly established question and come back to first analyzing whether or not there was truly a violation. That might give us a body of case law that would be instructive, because as Mr. Sutherland doesn't realize, no matter if the police officer reads case law or not, their trainers do. And if the trainers get that case law, then they'll be properly trained to be able to handle those things in the field.
Those are really interesting comments, and we may get back to those in our Q&A. But for the last question, I'm going to go to Senator Taylor. We know that the hate crimes bill that you authored was passed, but in a different, and some might call a watered down form. What are some of the immediate actions attendees can take to further the goal of police accountability with regard to qualified immunity?
Well, here's a couple of things, and I love this question because it gives a history of what when we try to make something applicable in the state of Indiana and what ends up happening at the end. So thank you for bringing up the fact that we do not have a qualified hate crimes law in Indiana. What we can do about qualified immunity in Indiana is make sure that we know succinctly what officers can and cannot do in efforts to do their job. One of the things that's very pressing with me is that we leave the prosecution of these officers up to local prosecutors. That is inherently a conflict. No one there are lawyers on this call. We all know we should be doing conflict checks because we know that the lawyer down the hall might have somebody that works in a firm. We might have somebody in a firm who has represented this person before, and we have a conflict. Well, we don't do that in local prosecution. You're going to try to tell me that law enforcement doesn't work with prosecutors across the state of Indiana? But then they're left up with the responsibility to prosecute these law enforcement officers. We need to have what I call a state independent board of investigation that looks into every case that is substantiated for police excessive use of force. Kind of like we do in the legal profession if we are subject to discipline by the Supreme Court. We are that case, if it's substantiated, is then moved on to individuals that look at whether or not we violated some ethical rules or others, and then there's a recommendation, and then the Supreme Court finalizes that recommendation. We could do that in the state of Indiana tomorrow. And we could do that through a licensing agency or creating an independent Bureau of Investigation to look at that. So I think that those are simple things for accountability without talking about qualified immunity.
Great, thank you. Okay, so now we're going to go to some questions, transition and to questions from the audience. And I think we have a first question that will go to Ms. Pactor.
I feel like I'm on Jeopardy. Go ahead. This is scary.
And I think these questions are going to come from our ACS folks.
Okay, I can go ahead and lead the Q&A if that's the case. The question that we would like the panel to briefly try and be brief in response to let everybody have a chance at these with the limited time. But we wanted to get the panel's reactions to Senator Mike Braun's proposed bill to reform qualified immunity in what appears to be a burden shifting versus the House proposal of a complete abolishment.
Sure, I can start with that. Just personally, and in the capacity of what I do, I think we should abolish qualified immunity. I see similar problems with the burden shifting approach. I frankly just don't see a reason to provide an exception to liability under a civil rights statute to precisely the people that the civil rights statute was intended to regulate. I think John's concerns are well taken about the possible effects. I would say qualified immunity is a very new doctrine. It developed in the 60s and exists in its current form as of the 80s. I'm not as concerned about the parade of horribles, especially when it comes to liability of individual officers. As we all know, every municipality has, almost every, has insurance policies that cover these things. That's precisely what they're intended to do. So I'm not particularly worried about that or training qualified officers. I have to say the other concern here is that the reason why we're in such a different situation in 1982 than we were in 1967 is that we now rely on a broken windows model of policing that is proactive, that results in many more contacts between law enforcement and the community. So if we were able to minimize those contacts, as I think a lot of people are advocating, probably also many police officers, we would alleviate many of the concerns and do away with a lot of the need for qualified immunity in the first place.
Would any of our other panelists like to just weigh in briefly?
This is Michael. As Mr. Councilman said, it might deter police officers, but I do want them deterred if they're not going to do their job. I do want them to look over their shoulder if they don't feel like they're doing their job properly. And if it weren't for all the personal phone cameras now, we would have a lot of police officers giving a version which is totally inconsistent with the forensic evidence. So let me tell you how it really works. John, actually, his firm represents the FOP, and they are on call 24/7. And I just had a case a couple of years ago, in which the police officer shot and killed somebody in an open field, and the person had wrestled the officer's taser, but was 10 feet away, and the officer told him to drop it, and he wouldn't drop it, so he shot him. We settled that case before summary judgment. But I want to point out that the FOP attorney was there to coach the officer, to help him write his report. He had 4 days to write his report, which was normally due on a single shift. So there are a lot of protections that the FOP contract gives the officer, in addition to this indemnification, which exists because of the contract and exists because of the insurance policies and exists with the state because we're self-insured, and it's set forth in the tort claims provision of the civil rights section that they will indemnify.
Mr. Sutherland, we have a lot of questions to get to. Mr. Kausman, I would at least give you the opportunity to respond.
Well, thanks very much. Quickly, with regard to Michael's comments, I would simply say the things that he told you are not entirely fact-based, and he doesn't have any idea on what the attorney-client relationship is with my firm and the clients, and there is no coaching or untoward witness tampering or whatever might be suggested in that effect. So that's just not true. With regard to the question that was posed to the group concerning like the Braun bill versus the House Democrat bill, I talked about, I think, the problems with complete abolishment of qualified immunity. I think the Braun bill might be a reasonable compromise. It would be a burden shifting to the defense. The problem with that is that much of the Braun bill is centered around whether or not there's a law that says that the conduct is legal or illegal or not, and legislation takes too long to develop sometimes. That's why it makes more sense to have some kind of a robust reporting system for the courts to quickly get the word out to the trainers so police officers can be trained on what they can and can't do.
I have to interject. First of all, let me clear something up in regards to the legislature and what we do. I've met with the FOP, and they will tell you straightforward that I've met with them. There's two things that need to happen in this dialogue. One is everybody needs to accept responsibility for where we are today. There's not one of us that have been part of this on either side of the issue that cannot say that we have some part to play in making this better. The problem that I've been having, and I just want people to know, your listeners to know this, is that law enforcement says they're doing everything right, and then the other side is saying they're doing everything right. Well, somebody has to be doing something wrong because it's not working. And here's why I say that. When I went to the FOP last year, I asked them to accept a bill that would require implicit bias training, that would require ongoing training, mental health services for their officers, and they said no. Now, there has to be something, because we can talk about qualified immunity all day, but it doesn't get to that point, and the people who are dying don't give a hoot about qualified immunity. They care because they want to be respected and they want to live. Law enforcement's job is to protect the public. That's the basic tenets of law enforcement. And if they're not doing that, then something needs to change. And I'm just telling you from my standpoint, we can either, there's only one thing to do, and that's to change what we're doing today. And somewhere, and I respect Senator Braun for at least bringing up the discussion. I have to agree with Ms. Pactor. I think shifting the burden, I'm going to tell you something. Those of us who are lawyers, we know that shifting the burden still doesn't shift the ideas.
Okay.
Yes, thank you.
Good.
Thank you, Senator Taylor. Moving on to the next question. If somebody can briefly provide an answer to this question, one of our attendees, how often do plaintiffs' 1983 claims overcome qualified immunity defenses? Does anybody have a factual answer to that question?
Well, I had pointed out from the only study I saw, the UCLA study, out of 1,200 cases, in the number of cases that it could have been raised in, qualified immunity was only granted 3.9% of the time.
So with that answer, though, could have been raised, could you elaborate a little bit on that?
I don't know what the details of the study are, but that's the way it was phrased. I'm assuming that they looked at whether or not a factual pattern was in place to allow the practitioner to raise qualified immunity, but I don't know the answer, Jesse, on that.
Thank you. Ms. Pactor, do you have any studies available?
No, I don't have any statistics on that. I have to say, when I heard that statistic, I was surprised, because for me in my own practice, it seems like far more than 3.9%, but I can't speak to any regional differences. I practice here.
Okay, and just to move things along, the next question to anyone who really wants to jump at it as we're trying to wrap up here. Should police officers be required to carry personal liability insurance similar to malpractice insurance for doctors or attorneys? Would that alleviate any of these accountability issues?
I feel like Horshack on Welcome Back, Kotter. Ooh, 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 ooh. Okay. Here's my idea, Mr. Councilman. Licensing, professional licensing of law enforcement officers in the state of Indiana that protects and that does the same thing as we do as for doctors, lawyers, and everybody else. Give them a raise, give them more responsibility, and then give them the ability, take it out of the hands of the local officials to penalize and take away licensing, and then leave it up to the locals whether or not they want to have a professionally licensed law enforcement agency or not. I'm going to tell you this as a person, a Hoosier, I would only be in a city that agrees to have licensed law enforcement officers.
If I might respond quickly to that, Jesse. The response to that is, Greg, there is a licensing process in place. It's called the Indiana Law Enforcement Training Academy. There is a licensure procedure in place where they can be certified and then allegedly decertified. There is a civilian merit board that decides whether or not they keep their job or not. Not insiders on the police department, but a totally civilian merit board decides whether or not a police officer has committed misconduct and whether or not they can continue to be a cop. So there's plenty of safeguards in place to address the concern that you have, would be my response.
Certification, respectfully, Mr. Councilman, certification is not licensing, and we all know that as licensed attorneys. The second piece is that police merit boards are different in every county in the state of Indiana. And if you go and you look at the structure of those, they are bureaucratic appointments, and they are represented in some cases by a majority of law enforcement officials. So I don't know how the citizens complaint boards that to me, that is totally political and bureaucratic, and we don't need that in law enforcement any longer.
Well, every disciplinary board, whether it be the City of Indianapolis Merit Board or the Sheriff's Department Merit Board or city merit or disciplinary boards, safety boards, are all populated by citizens, not law enforcement officers.
No, law enforcement gets, in Marion County's police merit system, Mr. Councilman, they are the FOP and the law enforcement agency gets 2 appointments out of the 7. The mayor gets 4, and the city and the council gets 1. So I would challenge you to look at the construction of all of those, and I would venture to say that everyone has a police officer on that board. No. And I'm not saying that they're biased. I'm not saying.
Real briefly, you're talking.
I'm going to come in here. Unfortunately, we're going to have to begin to wrap this up. I know we've had a really intense, passionate, and really thoughtful discussion, but I want to let everyone out there know that because there are a lot of people listening, and we had quite a number of questions that we were not able to get to, but we've kept a list of those questions, and we will ask the panelists to respond to those questions and get back to you all out there. So, so I want to start to wrap this up by thanking our panelists for their contributions, for being here today. We really appreciate your time, and I want to thank the ACS again for putting this all together. And I want to hand this back over to Jesse to take us out here.
Well, thank you, Professor Droback. With the time that we have remaining, let's go ahead and just continue the conversation. This is a conversation that we at ACS feel like we need to have. There needs to be a resolution from where things are currently. And we see that with the dissenting opinions from Clarence Thomas from the cases that were not granted cert here most recently. So we know that there's some movement here on many aspects of this issue. So let me get one last question. If you all need to run, please feel free to run. The meeting, I've been told, is not going to end, but the allotted time that we have is about to. But the next question is fair notice provided by internal policies and procedures or by court precedent alone? And how does that relate to maybe training for police officers with qualified immunity?
I can speak to the law and then maybe turn it over to John for the facts of how that works on the ground. An office's internal policies have nothing to do with the concept of fair notice as it's understood in qualified immunity. It has to be clearly established case law, and it has to be either from the US Supreme Court or the circuit in which the state is located where the event took place. It can't even be a trial court. It has to be, in our instance, for example, the Seventh Circuit or the Supreme Court.
Oh, I think that is a wonderful point, and I think you and I would agree upon that. I think maybe if there's common ground to be found here, if kind of one of the biggest issues that need to be identified is getting a better stream of information to the plaintiff's bar and to the police officer trainers on what is acceptable conduct and what is not acceptable conduct. Maybe legislatively or through the courts, they can work on a better system of allowing more vehicles to report what is a violation of rights and is not. Maybe instead of just Supreme Court opinions and Seventh Circuit or Circuit Court opinions, we develop some kind of a robust reporting system where verdicts also get disseminated to the trainers. And that forms the basis of teaching police officers what are violations of rights and are not. So I think that might be a good area for us to try to come together and work on something that would allow us to solve some of the problems, yet not completely get rid of the concept of qualified immunity.
So the problem is going to always remain that as long as defining the right includes taking into account the relevant facts and circumstances that any individual officer faced in the unique instance that they had, it's going to be very hard to generalize that into any principle of law.
Yeah, and I agree, and I don't think we'll be able to generalize it, but we might be able to take the specific fact pattern and whether or not that was a violation or not, and keep feeding that to the training bureaus is my point.
Well, let me weigh in. The fact that there were chokeholds and knee choking positions, that has not been the policies of the national police associations. In fact, they discouraged it, but it still exists, John. And so it's not just that the police are not trained; they know what's wrong. You can't do that. You had, you had the chokehold up in Chicago, and they still were doing it. As a measure of just how uncooperative the police are, the state police still don't want body cams. Marion County has just now agreed to have body cams. It was raised a long time ago, and the FOP opposed it.
Well, Mike, I'm sorry, I got to be heard on that issue. I want you to know that the local FOP 517 days ago were the first ones in Indianapolis to call for body cameras. And it was a current administration that put the slow walk on that. The national FOP actually convened a body camera best practices symposium and recommended the use of body cameras. So to say that the organized police bar doesn't want body cameras is absolutely not true and has never been true.
Well, hold on. Now I have to chime in because I want to defend Michael's position. When we passed legislation in 2016, Mr. Kaufman, your FOP did not support that legislation. Let's start right there. The second piece is you are correct that the Marion County Police Department, along with the FOP, local FOP, did support the legislation and try to get body cameras. But the reason why it was a delay is because there was a technology upgrade that needed to be had. So get that right too. The other piece is that there are over 300 law enforcement agencies in the state of Indiana, and less than 20 supported that police body camera legislation that we passed. I just want to make sure that if it's been in place since 2016. So every jurisdiction across the state has had 4 years to implement a body camera policy. But I would venture to say there might be 10 that have done it. Just stating facts right there.
Mr. Sutherland, if you could wrap up your response to where you were going to go just briefly. We are over by 5 minutes, and then I'll wrap things up for us.
Okay. So I have looked at the House bill, which wants to do away with qualified immunity entirely. And to me, that's the only workable solution. If you look at the Senator Mike Braun's proposal, he's got 2 or 3 good things: national registration for police misconduct that is verified, and 3, elimination of chokeholds. But that can be done at the local level. What you can't do is legislate jurisprudence, and that's what Senator Braun is mistaken about. You just can't do that. And it was created by the Supreme Court without any authority, without any, legislative history. But it can be taken away. That whole concept of qualified immunity can be taken away. And right now, the only bill that I see doing that is House bill.
Thank you. I have to blow the horn on overtime there. Just want to say to those that didn't get their question answered, we have a list of names and questions. We will maybe submit those to the panelists. If they would like to provide some responses to some of them, we can try to get a hold of you there. Thank you to our panelists. Thank you, Professor Droback. Thank you, IU. And let's dismiss from there. Thank you all. Good.